When are they going to get that? 18. But my will says 30. All right, good morning, everyone. Hope everybody had a great night. I did. Just a quick note as we're getting started, just letting everybody know I am recording this. It's probably going to end up on YouTube or whatever. Nobody else's face is in this, but your questions and voices will be. So, today we're going to be talking about panic at the probate court. Now, this really is a real thing. When I have people calling in, they've done stuff in a panic. It's like, and I've even had clients tell me, oh yeah, well I was at the funeral and my cousin said, oh, you need to do a notice to creditors and put it in the newspaper. Oh, okay. Oh yeah, you need to go down to the courthouse. They've got forms. I mean, at the actual funeral. And so what do? They're like, oh my gosh, I've got to do all this stuff. And they run and they start doing things and they're not doing it correctly. Oh yeah, you do have to put a notice to creditors in the newspaper, but until the paperwork's filed and you actually have a case number to put into that advertisement, it's not going to be effective or any good under the law. But that newspaper, they'll take your money. They'll take your money twice. Oh yeah, you run down to the courthouse and start this paperwork. There may be an exception for a smaller estate. So we're going to run through the process that I use in my own practice and try to keep it streamlined. But the thing I really would like to focus more on today is what can you do as these estate planning professionals who want to help clients avoid probate, but if it does happen, that you can explain it in as simple terms as possible and streamline things as much as possible as well. All right, so why do I do what I do? Some of you are going to have heard this story before, but I tell them, this is how I got into estate planning. My grandfather died about 2 weeks before I was going away to law school. And so packed up everything in the car, drove out, had my first day. My grandmother gave me 1 day.
If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel.
Day 2, she calls me up and starts asking me questions about the estate. I guess she, a proud grandmother, she figured I walked through the front doors and all the knowledge got dumped into me and suddenly I was Johnny Cochran or F. Lee Bailey and I knew everything because, hey, I'm in law school. Well, look, this is also the grandmother that dropped everything when my mom died and just moved in, helped raise me and my sister for several years. It's like, all right, she gets to ask whatever questions she wants. Now, I'm trying to answer her questions the best way possible that I could as a law student, because every time she talked with her actual attorney, she got an answer that she didn't understand and a bill that she didn't want. All right. The questions are coming every 2 or 3 weeks, and I realize suddenly it's 1.5 years later, and this is still going on. And I start thinking to myself, it shouldn't have to be this way. There's got to be a way to avoid all of this stuff. I've taken enough other classes and contracts, and there's got to be a way to avoid this. So all this time I'm running around the law library because that's what any first-year law student has the same answer to any question you ask them. It doesn't matter what the question is. It's, I don't know, let me look it up in the law library. I'm starting to try to figure out how can I avoid this, and I finally talked with the head librarian, and he said, I know exactly the book you need to read. We don't have it. It's this book called The Living Trust by Henry W. Apps III. They have it over at the mall bookstore. So I went, I got it, I read it, and I said, this is definitely going to be something I'm going to be doing in my practice. And it turned out it's going to be the main thing that I'm doing in my law practice. And so why do I do this? It's because I want to help people avoid what my grandmother went through. So I have been doing this for quite a while, practicing for 28 years, so of course I started when I was 12. I'm a certified Medicaid planner, and that's something I'm going to talk about a little bit later in a spotlight. And we're going to have a kind of online YouTube Q&A session if anybody wants to know more about Medicaid planning, and that'll be next Monday. I've authored, I put 9+, and I think it's probably 10 at this point. Here's my kind of rule about writing books. If I get the same question from 3 different clients in a 3-week period, and it takes me more than 15 minutes to fully answer the question each time, all right, that's it. I got to write a book so I can just hand it to them. I've started doing more with online courses around the same thing, but the idea is I need to save my time, so that's why I do the books and why I do the courses. And all the online courses, if you go to plainenglishattorney.com, they're kind of up there. Some of them are paid. There's some free stuff. I can go ahead and give you more information on that. And the goal for today is examine all of these basic concepts around probate, how to administer the estate. I'm going to use the way I do it in North Carolina as an example, but that doesn't mean the principles aren't going to be relevant to you. In a lot of states, it's kind of the same, at least the major steps. There's going to be different forms, there's going to be different things happening in these different stages, but this should at least give you a little bit of an overall picture. And then assess the possible exceptions to the full-blown probate. And this is different in every state. You probably heard, oh, at X number of dollars, you don't have to do the full process. It's the small estate, or whatever they call it, estate by affidavit. And we're going to just coordinate a little bit with trust settlement, because there's no way I can do it as well as Jerry did it yesterday. So I'm not going to go too much into trust settlement, just talk a little bit about how it integrates with it. All right, so clients just do stuff and they do panic. I had one client, it was an estate planning client of mine, but it was her mom. And she didn't call me. She actually said, I didn't want to bother you with this. So she did go down to the courthouse, like her cousin said. She was the one who put the notice to creditors in the newspaper before filing anything and had to redo it. And she's like, I don't understand why the probate court is giving me trouble with this. It's just gotten complicated. Jeff, can you look at it? Mom lived with my client, had one checking account, joint with the right of survivorship with my client, her daughter. That's it. There was literally nothing in probate. So we had to explain that she couldn't just take this account. It wasn't a probate asset anymore. But because probate was started, it had to be finished. It couldn't just be abandoned. So we did have to walk through the rest of this process. All because her cousin told her, oh yeah, you need to go down to the courthouse and file paperwork, and you need to put this notice to creditors in the newspaper. You probably, if you've been doing this long enough and you do handle estates and administration, you've probably gotten someone along the way. Can you help me clean up this probate? There's just a couple of questions I don't understand. All right. Even if you don't do estate administration, I'm sure you've come across the do-it-yourselfers. Well, I drafted my own trust, or I went online and I did this. Can I just pay you to take a look at it? Stay as far away from those as you possibly can. Because what they're really saying is, I don't want to actually pay you what you're worth to do this. Right. I want you to check my work, but I want you to be 100% responsible if I mess something up. So I learned a long time ago, I'm not going to mess around with that. Either we're doing it or we're not. That's it. All right, so I've also heard this, and this probably comes more down to trust funding. Hey, I thought we had a revocable trust. Why are there assets in probate? Well, this comes over to the whole thing. What does probate cover? It's titled in a deceased person's name. So if something is titled in a deceased person's name, there's no right of survivorship, it wasn't with a beneficiary designation, nobody else's name was on it to automatically inherit it outside, then it is a probate asset. Now, I'm also, I don't know if you've come across this, I've had some financial institutions, in particular, there's a couple of notorious banks in my area, where even if it was pay on death, they're requiring letters testamentary from the probate court. Wow. They're telling our clients, oh, our accounts are beneficiary driven. I've heard that term over and over again. And then somebody passes on and the beneficiary calls up, well, yeah, I'm a beneficiary on this account. I need to get this control of it. It's like, oh, okay, well, we got this form to fill out. We need a copy of your ID. We need letters testamentary from the probate court. We need, whoa, wait a minute, letters testamentary. They want that. Oh, we just need it as part of the paperwork. Look, that's when you yell and scream at them and threaten to go on YouTube or TikTok or wherever and say they lied to us because they said this was just beneficiary driven. We should just need a death certificate, and they make the check out to the beneficiary. But I have come across some of those. All right. Let's see. And also in funding trusts, like I mentioned, yeah, I thought we had a trust. Why do we have probate? And it's because they didn't fund the trust. There was one case several years back where we did the trust, went through, here's what needs to be done to fund the trust. The daughter, who was authorized to talk to me, so no conflict of interest there, she kept wanting to make sure that mom's plan was solid because she's probably going through a divorce, not the mom, the daughter. Well, is everything in the trust? Yeah. Okay, then you don't have anything to worry about because you're the beneficiary. Calls up 9 months later, I think I'm almost ready to file for divorce. Is everything okay with mom's trust? Yeah. Do you want to put mom on the call? We can talk about it. Everything's in the trust, right? Yeah. Mom dies. She calls me up. The financial advisor says this has to go into probate. Well, it shouldn't because everything's in the trust. And she sends me the paperwork. No, it's in mom's name. And then she says, well, what do you mean by in the trust? Everything except the house went through probate, which, okay, we handled the deed for that. So that was taken care of. All right, so this does get to those kind of legal versus the common definition of probate. What exactly are we talking about here? Actually, I'm going to back up 1 second and just make one other point. Funding your will. Does that make any sense to anybody?
No.
It actually should. This is a point that you need to make because a lot of clients just figure, oh, if I'm doing a will, all right, I know my will means probate. I'm going to do other things to avoid probate. Divorced father, I've got 2 kids. I want to make sure they're the beneficiary, so I did the will and I'm drafting everything out. It's like, okay, kids don't get anything until age 30. And then they go to their life insurance guy and list their 2 kids, age 5 and 7, as beneficiaries. When are they going to get that? 18. But my will says 30. The will only controls what goes into probate. And therefore those age and the other restrictions, they get so much at this point or whatever. If it's not in probate, it's not going to work. So this is kind of how I present things to my clients if they're trying to choose between a will and a trust. Either you want to avoid probate or it doesn't matter. But let's line up your assets to make sure it complies with what your one written plan is. Because when you start doing everything by exception to avoid probate using these other things, it's not a coordinated plan anymore. All right, so that's the legal versus common definitions of probate. And this can drive some of my clients crazy. Like, yeah, we need letters testamentary from the probate court, even though it's pay on death. Do you think your clients think that asset's in probate? Yeah. What if, okay, and this is another big thing with North Carolina that I've come across several times. If it's pay on death, it goes into a certain section in the probate forms, but now the probate court wants proof that it was pay on death. So you're dealing with the probate court, but it's not in probate. Oh no, they just need to get all this paperwork for the probate court to prove that it's not in probate. How is that avoiding probate? It's not really. If it's in your trust, it's not owned by anyone. It's not payable upon death after the fact. It's currently inside the trust. Now, I don't necessarily see this as much with IRAs and life insurance in North Carolina just because that's a different part of the form, but definitely the joint accounts or bank accounts that had a right of survivorship on it. I'm sorry, that had a pay on death beneficiary on it. So, let's see. So, probate has to approve the transfers the way I explain it to my clients. Otherwise, that's the legal definition. Common definition is, all right, you got to deal with the court with anything. All right, so required paperwork to prove something wasn't. Financial institutions required letters testamentary or administration before releasing funds to the beneficiaries. I'm currently working on a case where I've been working with this financial institution, the same advisor, for like 15, 16 years. Hadn't heard from this particular client in about 5 years. She had me be the executor because she had her closest friends weren't able to do it at that point. I promise as soon as this is done, we'll put them back. Didn't hear from her despite repeated follow-ups. She died. I have no idea what's happened to her assets in the last 5 years. We had to have her friend pay for the funeral because I couldn't even get enough information from the financial institution to know whether or not there was going to be enough money in probate to pay for the funeral. I wasn't going to guarantee that. So probate is based on title, and it's really just a massive, expensive, time-consuming, frustrating retitling process. That's all it really comes down to. So when you're talking about retitling the assets into a revocable trust to avoid probate, yeah, that's a good big thing. So this is the 4 downsides of probate, and I'm sure you've heard this or read this in Henry's book. This is what I also put in my book, Estate Planning Basics. Now, that is available on Amazon.com, but I also have free versions at freetrustcourse.com. I've got a PDF and an audio version. It also has the questionnaire that I use in my office. Look, I don't mind if you want to kind of borrow this education piece, if you want your clients to walk through it, because it does talk about that I have other courses that they can buy, so fine. But if you can, this can help you explain to your clients ahead of time, here's the difference between a will and a trust, and here's these big 4 downsides. Please go ahead and use it for whatever it's worth. So what are those big 4 downsides? 1, probate is expensive. There was an AARP study that Henry referenced in the Living Trust way back. I don't think there have been any really comprehensive studies, because the probate attorneys don't want those studies out there. And that study showed about 8 to 10% of an estate gets eaten up by the process, largely through legal fees. Now, I can tell you from just my experience, it's a little closer to 4 to 10%. And there's kind of this baseline of 5% seems to be the big thing. I'll get to an ancillary probate proceeding where that 5% came in, and it was ridiculous, but look, that's what it was. So it's expensive. Delays, 6 months to a year and a half. Now, I know this is very highly state dependent, but there is a minimum period of time in which you can do probate. You can't send the filings in, and then a week later, there's the next phase. And then a week later, there's the third phase. I don't care how quickly you do this. If you have a requirement that notice to creditors has to be published, there's a waiting period. Now, North Carolina, I'd have to go back and check exactly whether they clean this up or not, but we actually have a conflict in the statutes because in one place it says 3 months and the other one it says 3 months or 90 days. We wait 93 days just to be sure and that it's done. But there's at least that minimum of 3 months. Also, in the statutes, there's a full month after somebody dies before they will at least approve an administrator or an executor to make sure nobody else comes forth with a newer will, or someone who's a closer next of kin wants to be the administrator. So there's minimums that are built in. It's more open to being contested. Now, this is definitely more of a selling point if you're talking about doing a revocable living trust to avoid probate versus a will, but this is how I explain it to my clients and in the book. Probate makes sure that the attorneys get paid, because the whole big underlying theory behind probate is we want to make sure we get this right, down to the penny. We got to make sure we get this right. So it is very, very common in most states, I'd say, I can't say all, that if somebody brings forward a will contest and there's even something that the attorney can hang their hat on, then the court's going to make sure that the attorneys get paid. If it's a revocable living trust and this beneficiary is coming forward, I don't like this, I don't like what's going on, I want to contest this, and the attorney looks at it and says, well, okay, we could try this, but I need $10,000 retainer up front. Oh, no, you get paid when we make the money. Oh no, that's not the way it works. And I find suddenly people who want something that they're not entitled to don't really want to put up their own money to try to get it. So, and then the last one, privacy. When you're filing probate, at least in North Carolina, the names, ages, and addresses of all the beneficiaries becomes public. Everything that they're getting becomes public, so they know. Now, this was obviously long before the COVID lockdowns and the courts started doing more mailing in, and even now we're kind of moving to online. There were marketing people who would go in maybe twice a month, go through the files, and write down the names and addresses of people who are getting money. And it's more than 10 years ago. I had a client call me, and he said, Jeff, I have a Friday afternoon question for you. That was his way of saying, I'll ask you this question as long as you're not going to bill me. All right, fine. My dad died in Michigan about 4 months ago. Does that have anything to do with the fact I'm getting all of these brochures from Mercedes and BMW and Lexus? Oh yeah, they saw you're getting a bunch of money and they want to be first in line to help you spend it. Isn't that nice?
Wow.
So yeah, they end up on the marketing list. If you've got your revocable trust set up and you have a pour-over will, the only name and address in those filings is for the trustee, and the marketing people tend to leave them alone. So those are the 4 big downsides of probate. I didn't say it up front, but if people have questions and want to interject, this is 2 hours. I'd rather answer your questions than just drone on and on. Yes?
Jeff, can you give us the website to get your basics book?
Okay, well, let me give you two, because Medicaid planning is going to come up. freetrustcourse.com. So freetrustcourse.com. And the other one for Medicaid planning, if you're interested in that, freemedicaidcourse.com. So that second one has my book, The Long-Term Care Solution, and a couple of other things along the same lines. Thank you. Any other questions? Okay. So I mentioned will planning and not funding your will. So people, why are they so mistaken about this will? It's because the attorneys are looking to get probate work. Sure, we'll do a will for you, no problem. A lot of attorneys that just kind of, they're kind of just doing estate planning as a side gig, they'll just do the wills because they're asked. Yeah, Jerry.
Yeah, my favorite thing about lawyers and wills. After we sign your will, we'll hold on to it for you.
Yeah.
And we'll do it for free.
Yep. They'll hold on to it. Well, somebody else here said it yesterday. Actually, I think it was David. They look at that stack of wills or the drawers full of wills, they call it their retirement plan because that means probate work. I mean, I get it. But now, on the other hand, if you've got some banks and financial institutions that get yelled and screamed at because, well, where's my money, where's my money, where's my money? Well, that's why they do beneficiary designations, pay on death. It gets that stuff and all those questions off the table as soon as they get whatever paperwork they need. So they're washing their hands of it maybe within a couple of months. It's not dragging on for a year or a year and a half until probate closes if it's POD or it's joint with the right of survivorship. So if you're going to have that will, you do want to make it line up with your assets, line up with the will so it controls it. But oh no, I want to avoid probate. Okay, and this is how I explain this to my clients too. If your transmission is falling out of your car and you need to get it fixed, if you get a mechanic that says, well, you can just duct tape it, that's fine. Yeah, your transmission may not fall out of your car for a couple of days. Maybe it's enough to get it to the repair shop, but that is not a permanent fix. I call beneficiary designations and joint with the right of survivorship a duct tape solution. Obviously, when we start talking about things like IRAs and 401ks, there are other reasons to do beneficiary designations, but by and large, if you want to avoid probate, don't do it by one of these hodgepodge things. My clients want a coordinated plan in one place.